Okay, so we may as well get started. Hopefully everyone can hear me. We have, so good afternoon and good evening or wherever you are in the world. Welcome to the SOAS LEDC Summer Seminar. And the title for today's seminar is, What Does Post-Growth Mean for Law, Human Rights and Development? So as the kind of title suggests, we're looking at the intersections of these subjects. And today's panel discussion is really part of a broader project that we've started at SOAS with University of Essex, University of Cape Town, and National Law University in Delhi, looking at the intersections of post-growth, degrowth, and law. And this is really because there's been a sort of established and burgeoning field of scholarship and activism on post-growth, degrowth from social sciences and humanities, but less so from human rights, law subjects. So we saw this kind of gap in this research and in this work. And so hence we're kind of taking an initiative in terms of having some more conversations and scholarship around it. So today's panel will have three speakers broadly addressing this topic. Each panelist has about 10 to 15 minutes. And after that, we have a kind of Q&A. So we should be roughly finishing around 5:30 UK time. So I will introduce the speakers very briefly. Their bios are on the event registration page, and then I will then they'll have the floor, and then we'll come back for Q&A. So our first speaker is Ashish Kothari. Ashish is the founder member of Kalpavriksh in India. He's got many decades of experience working as a scholar activist in India. He joins us today, I think, from Germany, however. Our second guest is Dr. Margot Salomon, who's a associate professor at LSE Law. She works on human rights, socioeconomic rights, and the political economy. And finally, we have Professor Sam Adelman from the University of Warwick. Sam works on questions of law and development, climate change law, legal theory, amongst other things. So without further ado, I'll give it first to Ashish. Ashish, the floor is yours.
Thank you. Can you hear me?
Yeah.
All right. Thanks a lot. Thanks, Birsha. Thanks for this opportunity. And hello also to Margot and Sam. Very happy to be part of this conversation. So I'm going to start off my comments talking about, well, the Earth just reminded me, I'm sitting in Kassel in Germany, just reminded me of what we are doing to it. We just had a massive thunderstorm, rather unusual in this season, in this time, with hail and lashing winds and rain for about half an hour. We are seeing the consequences of what we've done to the Earth all across the world. Of course, the people most facing the biggest brunt of it are the ones who have least caused the climate crisis. But these are daily reminders for us now, whether it's heat or it's thunderstorms or it's floods or it's droughts or whatever other local manifestations we might be facing. In the light of the growing evidence of what human activity has done to the planet, to all species, including ourselves. It seems to me that we need to increasingly accept that growth or development within which growth is the sort of major, is the main means, is a failed God. It is failed. We're seeing evidence of that, but unfortunately, most governments of the world still cling on to it. And so development is still viewed by virtually all countries of the world except Bhutan in terms of GDP growth. And even if you look at the sustainable development, the SDG as a whole, you will find that one of the goals is economic growth, without the recognition that in fact that goal might be undermining a whole lot of the other goals of ecological sustainability and equality and justice and so on. So this is something that I think we really need to be able to understand, expose, and also try and figure out why is there this continued addiction to growth as the sort of singular indication, especially GDP as a singular indication of whether a country is developed, quote unquote, developed or underdeveloped or developing. We're also seeing that as it becomes harder and harder for governments and corporations to hide the consequences of this so-called development and growth, they're getting cleverer at greenwashing it. So we have green growth, we have green capitalism, we have the green economy, we have net zero carbon, we have carbon trading, we have all kinds of stuff happening, including, to my mind, sustainable development. All of them either internal contradictions or at best superficial solutions to the fundamental systemic crises that has been caused by this model of growth and development, which is underlaid by statism, capitalism, patriarchy, racism, and so on. So therefore, I think the single biggest quest for humanity right now, and especially for those who are most badly affected by the consequences of this, is the search for radical alternatives. Do we actually have other options for meeting human needs and aspirations without causing the sorts of crises that we are all confronting right now? And I think what we're seeing around the world is that, in fact, there is a resounding yes coming from the ground. That is to say, community after community in many parts of the world actually saying, yes, we do have alternatives. We're not bound by the Margaret Thatcher diktat of there is no alternative, the so-called Tina diktat that she had. There is, and not just one, but there are multiple alternatives. There's what we call a pluriverse of alternatives. And we can actually see that on the ground, whether it's in terms of practices like agroecology and food sovereignty, radical local democracy, energy sovereignty, localization of basic needs, all kinds of things, both in rural and urban areas, where people are actually trying to practice ways of meeting their needs and aspirations without trashing the earth and without creating the kinds of inequalities that we see. But also worldviews and visions and concepts and ideas and theories, which are well beyond. I mean, of course, they build on the greats of whether it's Marx or Gandhi or others, but also well beyond that. Indigenous visions, for instance, feminist visions, eco-feminist visions, and worldviews, which are worldviews that actually celebrate not money and fame and power, which is what the currently dominant system does. So if you look at celebrities, who are the typical celebrities in the world, they're the ones who have become either very famous overnight or very rich or are very powerful, or in some cases, all three. And that's what our kids are also being taught, that you really want to become successful, you need to be able to do at least one of these three, if not all three. Whereas in fact, these grounded alternatives, both practical and worldviews, are actually telling us that what we need to celebrate is life in all its complexity, all its wondrous diversity, natural life, including human life. And then what is it that would actually sustain this life on Earth rather than diminish it? I think what's also very important for us is that even as we look at this bewildering diversity of solutions and responses coming from the ground, and there's lots of publications available on that. We also look at the interconnections between them. What's common? What's common, for instance, between, let's say, the Zapatista and the Kurdish movements of self-determination and eco-feminist living and so on, and say the food sovereignty movements in India, or the solidarity economy movements in Europe, or the degrowth movement in Europe, or other such things? You know, what is it that, are there common threads, or are we just basically talking about such an incredible diversity that we don't have something that's common? And to my mind, I think what is actually binding us together, or could be further binding us together, are values, ethics, principles. For instance, the principle of regenerative existence, not existence where we're extracting more and more and more or dumping more and more and more into natural ecosystems. The principles of human beings being within nature, not outside of it, of respect of all species, all life, not just human rights, since that's a part of our topic today, not just human rights, but also the rights of the rest of nature. Equality and dignity, again, for all species, not just humans. The principle of self-determination, that people, that communities, collectives need to be able to determine their lives, but in ways that don't undermine somebody else's ability to also self-determine and to be happy and satisfied. And here we bring in the very important and very sort of deeply democratic notion of Swaraj from India. Swaraj, in a very bad translation, means self-rule, but essentially it is this notion of freedom, autonomy, independence, self-determination, but with the responsibility of ensuring that there's nothing that I will do or my community will do which will undermine your ability also to be free and autonomous and self-determined and happy and be well, right? So there is a notion of constraint or restraint that's built into the notion of rights, which I think is really, really important when we look at or redefine democracy itself. The notion of the commons, the principle of the commons, that all of nature and all of what even human beings produce, including ideas, are not there for privatization. They're not for private profit. They are actually and should be and have, for the most part of human existence, been in the commons, except over the last the colonial period when more and more has been enclosed and privatized, including with ideas. The notion that became so very important during the COVID pandemic of solidarity, of living with the idea that it's not that the economy or nature or society is not just for me, it's for everybody around us. And if others are suffering, as we've seen during the COVID pandemic, I should be able to step out of my comfort zone and help them. And we saw wonderful examples of that during the pandemic. And these are many. I'm not going through the whole list here, but I think these are the sorts of ethics, principles, values which have been lost in this period of colonialism, in the period of industrial modernity, etc., which has emphasized completely the opposite set of values. And these are what, in fact, the grounded responses are bringing back, and we need to learn from them, build on them, connect them further and further. Now, in terms of the law specifically, since that's an important part of today's discussion, I think what's also emerging from these alternative perspectives, both the law and with human rights, is that we need to go well beyond the formal Western legalistic notions of how we look at things like rights, or how we look at things like crime and punishment. And a lot of this, for instance, many of the indigenous peoples or many of the more recent movements towards self-determination look at the issue of law from a much more wider and deeper perspective. It's about things like customs. Now, instead of having to write down the law and impose it and have punishments when somebody violates it, it's something that you actually grow up with. You internalize as norms, as customs, as practices that are part of your daily life. For instance, when you're dealing with nature, people don't have to be told that, look, it's illegal to hunt a particular, say, a pregnant deer. It's just part of what you have learned as you're growing up. You just wouldn't do it. You wouldn't think of doing it, right? So the more we're able to actually extend the domain of law into everyday practice as custom, the more we can actually break out of a very formalistic sense. The more we're able to actually look at things like crime and punishment in the form of restitution, in the form of, many indigenous peoples, for instance, say that if somebody is committing a so-called crime, it's the society which is the problem. It's not the individual. And so one needs to deal with it as a social phenomenon. We have examples in central India, for instance, where villages have their village assemblies, where all the people are involved, men, women, sometimes the children also. And issues of conflicts and so on are dealt with through that process. Now, I know, and of course, it is very true that in many of these situations, there are also power dynamics that play. So you might have gender inequalities, or in the case of India, you might have casteism. And that could become worse if it's only a situation of a local community deciding everything. So we also need the longer, the larger, the more landscape level connections where there are checks and balances, where somebody else can come and say, hey, listen, it's fine that you're working with your own customs, but there is a bit of an issue here in terms of gender inequality. And it's that kind of dialogue and churning that takes place. As a simple example, in central India, there are 90 villages that have got together as a federation of village assemblies. And in that, the women have their own separate process going on to empower themselves, to become confident, to have a voice, an equal voice in that federation, where that federation meets for taking political decision making or economic decision making. And so you actually have the struggles for social justice also built into the struggles for justice, for instance, which goes well beyond just a formal legalistic way of looking at it. Similarly, with human rights, I think one of the most important messages or learnings we get from these is that human rights goes well beyond the UN Declaration of Human Rights kind of thing, which is again a very Western way of looking at it, because it's mostly individual human rights, which is of course important. It's crucial that individual human rights are protected. But the UN Declaration for the Rights of Indigenous Peoples, for instance, goes well beyond that in terms of talking about collective human rights, which in some senses, in fact, they're saying are much more important or equally important, so that the individual right is not actually undermining the collective interest, nor vice versa. So what is that balance also in terms of human rights? I think there's a lot of very interesting work happening on that. I think I'm not able to share my screen. Maybe if I can figure that out, I'll show you what we use. The last point I wanted to make here is that one of the things we use here in our process in India, where we try and bring a lot of these radical alternatives movements together, is what we call the flower of transformation. To look at these changes and transformations taking place in all these different spheres of rights and responsibilities and customs and laws and so on, from a holistic perspective. If, for instance, there is economic transformation taking place, what is the impact on the ecological, the social, the cultural, the political domain? If there's a struggle for local self-determination, political self-determination taking place, what are the impacts or what are the implications for the local ecosystems, for the social relationships, for cultures, for the commons, etc. So it's a way of kind of taking a more holistic, systemic analysis of both the problems and the positive transformations that are taking place. And then the ability to build on these across landscapes, across countries, within countries, across countries, and in fact, even rethinking political boundaries from ecological and cultural perspectives. That's where I think scale can actually be looked at, because one of the most obvious questions that arises is you might have thousands of wonderful examples around the world, but at the macro scale, they're still not making that impact. We're still facing the problems we're facing from the structural systems. So how does scale get created? To my mind, is where you have these thousands of grounded initiatives actually beginning to come together to network.
We can probably move ahead because I think Ashish was pretty much wrapping up. So maybe we'll move ahead to Margot, and then Ashish, I'll ask you to come back at the end, maybe if you had anything else to finish off with. So thank you, Ashish. Margot, floor is yours.
Okay. Hello, everyone. Good evening, and thank you so much, Birsha, for putting this together. I think it's timely. I think it's really interesting, and I'm very happy to come out of my beginning of summer winding down mode to be part of this this panel. And I was delighted also to hear Ashish speak, and I'm also really happy to be on a panel with Sam. So this is a fantastic lineup for this really important topic. So what I want to do with my time is to tell a short story of effectively the past decade of economic, social, cultural rights and where growth is situated, with the aim, of course, of thinking past it. There, Ashish is back. I don't know, Birsha, if you wanted to bring him in, or if he should come in for Q&A, what would you like to do?
Margot, go ahead. I'll finish my points in the Q&A. Please go ahead.
Okay, thank you. Okay, so I'm going to look at the last decade at sort of 3 points and situate growth and offer some critiques and map the terrain a little bit as I see it. So the first sort of element, the first intervention, is the question or the issue around what prefigures seemingly progressive social policies in the area of human rights and socioeconomic rights in particular. So if we go back a decade to 2013, there was an attempt within the UN system, expert system, to influence the negotiations around the Sustainable Development Goals, and we saw 17 UN special rapporteurs recommend that the SDGs include a goal on the provision of social protection floors. And then we see a couple of years later, the Committee on Economic Social Cultural Rights, which as many of you will know is the main judicial or quasi-judicial body that is charged with interpreting and monitoring compliance with the International Covenant on Economic Social Cultural Rights. So that committee comes together, they issue a statement on social protection floors, an essential element of the right to social security and sustainable development, it's called. And ultimately, as we know, the SDGs reflected this goal on social protection floors. But the problem is that the committee's reaffirmation of the redistributive character of social security to meeting basic needs and furthering equality, as the committee puts it, when left there, obscures the economic arrangements that engender that poverty, engender that inequality, and human and environmental alienations in the first place, economic arrangements upon which the committee quite systematically relies and has relied. So what we see is that subsequent statements actually position growth as a precondition to the realization of human rights. And this is the model that's deployed. So instead of probing the terms under which, and I quote the committee here, the terms under which many developing countries have experienced relatively high growth rates, the committee actually hitches the social protection agenda that it's advocated for to the existence of that growth to argue for access to the resources needed to initiate and progressively implement social protection programs. The problem then is that the committee endorses social protection floors without challenging at the same time or fully the fierce means by which they'll be provided for. And this would include support for a conventional model of economic growth without accounting for its contradictory effects. So the committee has long emphasized that the covenant is politically and economically neutral, and that its principles are subject to the realization within any number of systems, quote, socialist or capitalist system, mixed centrally planned or laissez-faire economy, or upon any other particular approach. But its willingness to endorse growth uncritically, with all its attendant harms and dislocations, is to allow for the transfer by the state of the profits of the transnational capitalist growth economy to the subsistence economy, which effectively helps sustain and legitimate the capitalist growth economy. And from here, I draw some inspiration from Partha Chatterjee on his writing around legitimating post-colonial capital. So what's required to address this quandary is, to start with, a far greater awareness of how the interpretation of international human rights law within an area of capitalism, of global neoliberalism, sees transnational growth fetishized as an essential precondition of human betterment, and how distributional and ecological violence prefigure these seemingly progressive policies. The interpretation and application of international human rights law has, in my view, a foremost function under conditions of economic globalization, and that's to ensure that its terms don't help reproduce the violent appropriations of capitalist globalization. And this would offer an important first step in any so-called neutral application of socioeconomic rights. And this is but one example of what the sociologist Anthony Woody Weiss refers to as the human rights paradox, right? This idea that human rights are intended to protect potential victims by declaring aspects of their lives sacred, but they also contribute to the continuation of the possibility of abuse by protecting some of the very activities that gave rise to those very abuses. So to begin the process of overcoming this paradox, it needs to be consistently exposed. Thus, along with its mandate to protect the most vulnerable, the Committee on Economic Social Cultural Rights could endorse social protection floors, but it should do so by also stating that in those protections and by advocating for those protections, the committee doesn't necessarily endorse the means by which the needed redistribution is made possible. And from there, the committee should turn to what I've referred to in others as the pre-distributive requirements. They'd be subject to a separate and related inquiry into compliance with the covenant, so separating those two elements out. Second, recognize that the social protection floor, like minimum socioeconomic rights or welfare rights more generally, are but a response to capitalism, right? They're remedial, they're compensatory, they're necessary for sustaining capitalism. Also to consider that the idea of socioeconomic rights, right, like welfare rights, is not coextensive with decommodification, right? There's a focus on the possibility for commodification within social protection and within socioeconomic rights. So it really doesn't guarantee any move away from our models of commodification, no less alternative models of ownership and more radical approaches that we've seen and that Ashish has articulated. What we see, and the economist Jayati Ghosh, among others, has articulated really beautifully, is we see with this commitment an amelioration of lives, of people's lives, which of course is significant, but not the economies, not transformation of the economies within which they live, right, and within which they function. So yes, the point is protect those in need, needless to say, but as part of a bigger change, as part of a bigger set of reflections, as part of a bigger set of inquiries. And here, I turn to many of the ideas that Ashish pointed out, commoning economic democracy, degrowth, post-growth. And I'm going to come back to say a little bit more about how we situate this at the end of my set of comments. Okay, so my second period during this on this timeline is we jump to 2022, something a little bit on the direction of travel. So a few months ago, in the end of last year, the Committee on Economic, Social, Cultural Rights adopted a general comment on ESC rights, on economic, social, cultural rights, and land. And so I'll start by saying that within the covenant, we have some provisions that we can really work with towards a progressive, or if one wants to talk about a sort of radical reinterpretation. And indeed, there's almost no legal provision or international human rights legal provision within the covenant, or more generally, that can't be reinterpreted to move beyond the dominant paradigm, right? The law is effectively what we make of it. And there's been dramatic, we don't have the time so much to talk about it today, but we can revisit it, the Q&A, dramatic reinterpretation from what was envisioned at the drafting of many of the human rights treaties. So that possibility remains wide open. But for the sake of sort of being systematic here, let me mention a couple of the provisions in the covenant that we should start thinking about, and that I want to comment on in particular. So Article 1 and 2, all peoples may for their own ends freely dispose of their natural wealth and resources. In no case may a people be deprived of its own means of subsistence. Article 11.1, states parties to the present covenant recognize the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. Article 11.2, the states parties to the present covenant recognize the fundamental right of everyone to be free from hunger. States parties need to act, they need to take measures, including specific programs in a number of areas, including, as per Article 11.2a, reforming agrarian systems. So the committee has started to harness some of these provisions and to think them through a little more fully. So in this recent general comment, which is right at part of their jurisprudential outputs on interpreting the covenant, the committee speaks to Article 11.2a and says that this provision implies that states have a duty to support agrarian reform schemes that ensure adequate access to land, particularly for small-scale peasants who depend on access to land for their livelihood. The committee also states in this general comment, and I think quite significantly, that large-scale land investments risk violating covenant rights because they often affect smallholders whose informal land use titles are often poorly recognized, etc. Such safeguards could include ceilings on permissible land transactions and the requirement that transfers exceeding a certain level should be approved by the highest level of government or by the national parliament. And the committee warns against some contradictions, for example, titling for commodification, highlighting the tension between aiming at security through land tenure while increasing forms of exclusion. So, we can move even further along these questions about the reinterpretation and reimagining the application of land rights understood in quite conventional forms, normally understood through the idea of the right to private property, which have been for 20 years now radically reinterpreted, not least of all, as some of you will know who work in this area, by the Inter-American Court of Human Rights with regards to the private right to property in the American Convention on Human Rights, which has been reinterpreted to provide protections to the collective use and ownership of Indigenous lands by Indigenous peoples. And here, moving even further, what we see through that line of interpretation in the African regional system has done the same, is a focus on land for its use value and not its exchange value. And not its exchange value as as directed toward export-oriented growth as per the SDGs. So we see some significant movement in this regard. We can mention also, and Ashish mentioned the Declaration on the Rights of Indigenous Peoples, but the recent Declaration on the Rights of Peasants. We see access to control over the means of production, community-based commercialization systems, traditional methods of farming and fishing, right? New articulations of rights or new ways of articulating rights that we've heard already. We have for the first time a right to seeds, to save, use, and exchange seeds. So what we see here is the possibility for international human rights law, particularly through these fourth world contributions, really significant systems of reconciling social, economic, and environmental imperatives, again, unlike the SDGs. And here, I've written on this somewhat recently, it would be helpful to think about these contributions as economic culture of peasant communities, for example, or Indigenous communities, rather than economic arrangements, particularly because this is embedded in cultural systems, and international human rights law provides particular protections, and particularly significant protections to culture when it has to do with protecting traditional ways of life, or protecting particular characteristics, or even non-discrimination, right? So culture has a particular purchase, and so these are more than economic arrangements. These are actually economic arrangements that reflect culture, and there's a particular element there that could help advance some of the more radical ways of thinking about this and applying this. Okay, my third comment, then we jump to the present, to this year, and the Committee on Economic, Social, Cultural Rights is preparing another general comment on sustainable development and the progressive realization of socioeconomic rights, and they held a day of discussion to solicit interventions from a handful of academics, other experts within the UN system, and so forth. And I took a look at what was going on there, and I want to raise a few points in particular to challenge them. So one speaker during the day of discussion made the argument to the committee that the revenues from exploitation projects need to be shared with local communities. Now, I think this is a terrible idea. I'm very concerned about the idea of benefit sharing. Benefit sharing on these terms is a way of embedding the status quo. It's not the same. This isn't the benefit sharing that we would understand as emerging out of Indigenous customary laws, benefit sharing that emphasizes equity, fairness, helping those in need, and conservation values. And whether it's in the Peasants' Declaration, where there's a commitment to benefit sharing for exploitation, modalities for the fair and equitable sharing of the benefits of exploitation that have been established on mutually agreed terms between those exploiting the natural resources and peasants. So whether it's framed in those terms as benefit sharing, or whether benefit sharing is a remedy, part of the compensation that we see in a range of Indigenous cases where there's been, incursions or exploitation on Indigenous lands, and part of the remedy is to allow for benefit sharing in those exploitations. So we see deeply problematic deployment of this idea of benefit sharing at different moments of intervention. Problematic because they mask the structural subordination at the heart of contemporary capitalism, right, just as it contributes to its continuation. And in particular, it draws into global capitalism its most passionate opponents and those with the greatest experience to spearhead alternatives. So benefit sharing is is problematic, and I would challenge the idea that this should be incorporated into a general comment, certainly not on the terms that we've seen so far, not on the terms we've seen so far as deployed within international human rights law and judicial decisions within the case law. A second point about this day of discussion, another speaker mentions or referred to polycrises. And he refers to the climate crisis, the ecological crisis, COVID-19 pandemic, geopolitical instability, inflation, economic recession, and conflicts. And I'd like to propose, of course, there's nothing wrong with this, and it makes perfect sense, and we're all sensitive to this, but I would suggest that what if we thought about this, in fact, as one crisis, right, or stemming from one crisis, effectively the crisis of capitalism, which relies on growth and on profit and on private property. Would we approach their solutions differently through collective means, through ideas of economic democracy? So this idea that there's many crises, I think, misleads us from effectively looking at the root causes. And then there was an intervention, there were others by Jude Mosquito, which I really appreciated, I have to say. And this was great because Jude, who I think might even be here, I know she's done work also with you, Birsha, on this, on the degrowth and post-growth. So, you know, against these other interventions or the parts that I foregrounded, Jude highlights post-development approaches to climate change, right? Starts introducing these alternative ways of thinking quite fundamentally, and the need to recognize alternative environmentally sustainable lifestyles. So this post-growth thinking is tabled. Conventionally, international human rights law takes capitalism as its means of delivery, but it doesn't have to, right? It need not. And what I'm seeking to highlight here today with this talk is progressive realization of rights need not presuppose endless taking from the earth or endless taking from each other, and minimum essential levels of rights brings its own problems, right? So when we take the approach of minimum essential levels, which is really all we have at the moment, not least of all through a long period now of austerity, is really just protecting the most vulnerable and the least well off. But this, as you know, scholars have written about in the last few years, compatible with gross inequality, these minimum essential levels of rights, and effectively provide a safety net for capitalism. So they're not getting us very far in their current incarnation, and we radically need to rethink them. So I probably have used up my time. I haven't been paying much attention, but my closing remark is one key point. And that's to say, and this builds, I think, very nicely on Ashish's intervention, you know, we have mutually reinforcing paradigms that are emerging, and not only theoretically, but also in practice, that move away from fixes and instead towards a different kind of society altogether. And what's different now, and I speak here as an international lawyer, is that we have international lawyers, international human rights lawyers and international lawyers in the main. There's a long history of really fantastic critical engagement with international law. Since its inception, and certainly since its more modern inception. So there's no problem with critically engaging with international law. And there's a rich set of scholars, there's a rich degree of scholarship to draw on. But what we have now, I think, is something more important. What we have now is possible alternatives. I think this turn to thinking post-capitalism, post-development, and this conversation now between law and degrowth and international human rights law and degrowth is actually to do something that we haven't had before with the turn to third world approaches to international law and Marxist approaches to international law and critical legal studies before that, and all sorts of ways of engaging critically, is actually now to present these critiques, but also to situate them within very strong and growing and mutually reinforcing alternatives to the status quo, which I think makes this a considerably different project than we had before. Thanks very much.
Thank you so much. Thank you so much, Margot. Some excellent points that I'm sure we will get back to on the Q&A. And Judah's also here somewhere. And so she'll probably come in as well. Sam, the floor is yours.
Thanks. Yes, I too am very happy to be on a panel with Margot and Ashish. And I'm going to begin by mentioning something that Margot's just referred to, which is polycrisis, the polycrisis that confronts us, I'm arguing, requires fundamental ontological and epistemological transformation. It requires social, cultural, economic and political transformation, not least to development. It requires an axiological and ethical revolution and a legal paradigm shift. And I'm going to focus mainly on the law, as Birsha asked me to do. So degrowth is a qualitative rather than a quantitative concept. It's about well-being rather than quantities such as profit and GDP. In relation to development, as Ashish and other post-development thinkers have argued, the problem is development itself, since mainstream conceptions of development are invariably growth-driven and extractive, and the end of development seems to be development itself, which then tips over into the ideology of developmentalism. I have extensively argued that sustainable development, which is now the hegemonic conception of development, is a dangerous oxymoron because it is predicated upon growth and is therefore antithetical to ecological sustainability. And I think it's very important to emphasize the difference between ecological sustainability and sustainable development. And again, as Ashish and others have argued, what we don't need alternative forms of development, such as sustainable development, but alternatives to development that exists in the form of buen vivir, pluriversality, etc., that I'll come back to. So degrowth calls for less consumption, different forms of production, for frugal abundance, as well as socio-economic, legal and political change, because clearly business as usual, development as usual, and law as usual are existential dead ends, literally. Degrowth confronts two of the main pillars of developmentalism that are Western in origin, but eagerly embraced throughout the world, as much in the global South as in the North. And those are obviously GDP and extractive industrialization. Reimagining a different world through degrowth requires some things that are in short supply in our contemporary world, such as solidarity, which Ashish mentioned, including South-South solidarity, and collective cooperation, commons governance, another thing that you mentioned, and conviviality. As we speak, there are discussions in Paris today on a global financial pact to deal with global heating. We shall see what those discussions produce, or more importantly, what they don't produce. I think collective solidarity is imperative as a basis for redistributive global justice, which is in turn a precondition for climate and environmental justice. And all of these are inextricably linked to other forms of justice, such as gender justice, procedural, reparative justice, etc. Now, law very clearly promotes business as usual, and I've long been arguing for the need for a paradigm shift in legal teaching, in legal theory and legal practice in order to transform law's form and its content. In principle, it seems possible to alter legal rules and governance regimes to reflect the best available science, but we run into several problems. First, Eurocentric binary thinking is deeply embedded in liberal legal systems. This is symbolized by anthropocentrism and other hierarchies of legal personhood. Hierarchies between humans and more than humans, both natural and corporate non-humans, and humans on the planet. And this makes it difficult to move towards an ecological law that incorporates post-human hybridity, place, embeddedness, and relationality. Second, growth is hardwired into modern legal systems, and not least into domestic and international environmental law. And this reflects the neoclassical orthodoxy that growth is a precondition for increased tax takes and thus for welfare payments. Growth is inextricably linked in legal systems to credit, debt, interest, and rent. And so it is very, very difficult to alter the legal systems as a whole and the particular areas of law that deal with these issues: property law, trusts, company law, etc. Third, law is preoccupied with markets. It prioritizes individual and sovereign property above ecosystems and biodiversity, and promotes individualism and rights as putative solutions to collective transboundary problems. Fourth, contemporary legal systems are incompatible with Earth system science, with the planetary boundaries framework, and with climate science in general. So this raises a fundamental question as to whether liberal law is capable of being reimagined and decolonized in order to facilitate pluriversality, an ecology of knowledges, and to incorporate the wisdom of indigenous ontoepistemologies, indigenous cosmovisions. Degrowth promotes the idea of decentralized, autonomous, convivial communities of people living in harmony with their supporting ecosystems, consuming no more than they need, sharing as much as possible, and treating each other with fairness and mutual respect. As a result, degrowth requires radically different forms of legal and political organization that are commensurate with the scale and urgency of the climate and biodiversity crises that we're facing. So various thinkers have argued in recent times for Earth jurisprudence, more recently for Earth system governance, and increasingly for ecological law. And I'm going to focus on ecological law in the rest of what I'm going to speak about. Law in general, modern contemporary legal systems, and not least international environmental law, promotes a technocratic, managerialist, neoliberal, and depoliticized approach to climate and the environment. And this is very much so, for example, of the Framework Convention on Climate Change, the Paris Agreement, etc. As such, law is at odds with the insights of Earth system science and the planetary boundaries framework, and the need for holistic, dynamic, non-linear approaches to tipping points, feedback loops, and other insights of climate scientists. I think that a central flaw of environmental law is its reductionist tendency to treat ecological problems as discrete and isolated, because this impedes the integration of a systems-based ecological approach into law as a whole. International environmental law is fragmented, blind to ecological interdependencies, lacks normative ambition, and is therefore weak in comparison to law, those areas of thought that protect private interests, private property, and state sovereignty. In short, law in general and environmental law in particular treat nature as a set of inert resources passively awaiting commodification and monetization. Post-development approaches such as Buen Vivir, which is living well, there are many versions of buen vivir in Latin America. Post-development approaches in general point to ways forward in their critique of capitalism, and certainly the many versions of buen vivir do not contain anything similar to a Western style concept of development. Equally importantly, indigenous cosmovisions have fundamentally different understandings of the relationships between humans, more than humans, land and nature, and crucially, different understandings of legal personhood. A legal pathway towards degrowth requires recognizing nature as a source of law, as it had always been seen in indigenous legal traditions, and accords rights to nature, although this is not unproblematic, and perhaps we can come back to that in a later discussion. I think that indigenous ontoepistemologies open up possibilities of radically different conceptions of legal pluralism that challenge the domination and centrality of coercive positive law. What is required in order to bring about a paradigm shift is, alongside a legal paradigm shift, is the decentralization of power, subsidiarity, so that decisions are about nature are made by those closest to it, those whose livelihoods depend on it, and those who have proved to be the best historical stewards of nature. In short, place-based, communitarian, vernacular forms of law that include principles of equality, justice, sustainable production and consumption, and commons governance have existed throughout history, especially in indigenous legal traditions. The problem is in Eurocentric law and rationality. Ashish mentioned commons, and I think that decentralized common governance is essential, as I said, because commons governance should be undertaken and performed by those who are the best stewards of nature, the land, and the environment. There is a problem here, though, in the growing literature on degrowth, and that relates to governance in all forms, because degrowth lacks a coherent theory of the state. Its advocates correctly call for radical policy and social change, but as yet, there is no dominant model to explain how, why, and under what conditions such changes could come about and what role the state could or should play in it. Ecological law treats humans as part of the Earth's life systems on which their well-being depends, rather than actors who are paradoxically detached from the environment at which they are supposedly at the center of. It prioritizes ecological integrity and respect for ecological limits, which must have primacy over all other considerations, political, legal, and economic. Some have called for ecological sustainability to become an international environmental law Grundnorm, a kind of basic underpinning, a measurement by which all activity is measured, rather than, as is the case at the moment, say, we might argue that the Grundnorm in the international global political economy is free trade. But it's not enough to modify environmental law alone. Ecological primacy must permeate the entire legal system in ways that change property and company law, trusts, tort law, etc. In other words, a paradigm shift. I think that law schools have a huge amount to answer for, because for centuries, cohorts of law students have been taught that certain forms of behavior and certain rights are natural rather than profoundly problematic for all life on Earth. It's possible to change law's content in order to reduce the throughput of materials and energy in the economy. And this in turn requires changing things like fiduciary duties, for example, so that the primary obligation should not be to shareholders, but to ecological sustainability. The fundamental problem, I think, is political. I think with sufficient political will, law can actually be effective. I think ecological law is compatible with degrowth to the extent that it applies principles of proportionality and subsidiarity and hardens the many soft environmental law principles into hard law. Logically, ecological law requires consideration of future generations, and again, here Indigenous peoples think normally in terms of 7 generations. It requires consideration of other species, and it's difficult to conceive how future generations will inherit a habitable planet in the absence of the end to growth fetishism. Perhaps the most difficult thing to achieve is making ecological law binding and enforceable, in contrast to the current voluntarist climate and biodiversity regimes. Ecological law should certainly have precedence over institutions like the World Bank, the IMF, and the WTO. I have just a few more minutes and points to go. I think ecological law must incorporate the insights of Earth system science and the planetary boundaries framework at the risk of repetition. The much hyped recent 30-30-30 agreement on biodiversity last year in Montreal does not promote degrowth. So the 30-30-30 agreement is to try and preserve 30% of the land, of the water resources on the planet by 2030. And immediately I look at it and think, well, what about the other 70%? Why is this so normatively unambitious? I wonder whether legal systems that promote formalism, positivism, and mythologize objectivity, certainty, neutrality, and impartiality can actually be sufficiently adaptive and will be able to reflect how ecosystems in the biosphere operate in reality rather than as law constructs them, and whether it's possible for the law to reflect the intrinsic value of the biosphere rather than treating it primarily as a source of profit and commodities. We have lots and lots of law, including new treaties, as I've just mentioned, on biodiversity. We have a new oceans treaty, and there are negotiations for a new treaty on plastics. This is all very well and good, but all of this law is of little value if it is designed to facilitate appropriation, exploitation, and profit. We are confronted with the almost obscene prospect of COP28 taking place in the UAE later this year under the presidency of someone who's in charge of one of the carbon majors in the UAE. And we're at the point now where these magical gatherings of sovereigns, these conferences of the parties, are looking increasingly farcical. We're on COP28, so that's more than 28 years, because there wasn't a COP during the pandemic, for example, and emissions are still going up. So the irony of the capitalocene are very, very antagonistic to the idea of the Anthropocene, because it ascribes equal responsibility to all humans. And we know, as Ashish said, that's very clear that the vast majority of people on the planet are responsible for very, very little of ecological, environmental, and climate breakdown. So along with the alternative suggested by indigenous cosmovisions, post-human approaches such as new materialism and earth system science, I think degrowth offers ways of reimagining law and development in order to transform them. We are in the first stages of a growing backlash against climate action, and this is likely to intensify, certainly in countries like the United States, Australia, the UK. But law is also a terrain of contestation and resistance, and we see this, say, in the growing amount of climate litigation. And so it's important to actually be using law to the extent that we can, changing its form, content, using it in proactive and progressive ways in order to protect future generations and the planet itself. And I think that degrowth can be part of the paradigm shift that's required. So that's my contribution.
Okay, thank you so much, Sam. Really a lot for all of us to take in from all three panelists. I think there are already some questions coming in on the chat. So before I turn to those, Ashish, I know you got cut off. Did you have anything, last words to share? I know you shared a document on the chat, but.
Yeah, I did. I actually wanted to show that what I started referring to, the flower of transformation, just as sort of a visual. I'm not sure that I can actually share my screen. I'm going to try, but otherwise, Birsha, I've sent you actually a small document. If you can just open it from your side, I can speak to it over a minute or two.
Yeah, I think you should be able to share. Yeah, there, we can see your screen. So,
but can you? Because I can't see it myself, so I don't know. You're probably seeing the whole thing, right?
Yeah, we can see the whole thing. We can
see. Seeing the presentation?
No, we see a background, I think.
No. So no, I'm having a problem. If you
it's
got
a picture of some hills and ocean.
No, that's just the background. No, so anyway, I'll shut this, but I've sent it to you in case you're able to.
Yeah, I'll try and just share my screen. If you could just stop sharing yours and then.
Yeah. I stop sharing, or you can still see?
No, it's fine now. Sorry, I'll share. Okay.
No, not the. No. Not what I shared in the chat. I actually sent you an email. Anyway, that's
sorry. Yes,
taking up
I think we'll just carry on for now, just to get
questions. That's fine.
Yes,
that's fine. Yeah, we can take some of the questions. I also had a quick comment on something Sam said, just to complement what he said, but I can come back to that.
Okay. So we'll start with this question from Romain, which was, while indigenous philosophies offer models and directions for a post-growth system, can we use it in terms of European or global north shifts towards degrowth. And then we had a question from Jude as well. I think Sam started answering this just in terms of ecological law, earth systems law, wild law, being quite, theoretically very popular, and everyone can kind of probably agree with a lot of it, but how to move it into practice and beyond academia. So maybe we'll start with these two questions, and Ashish, I know you had a point as well, so maybe you could start off and then we can go to Sam.
Okay, I'll try and combine these two, and I'm sure Sam and Margot will have other things to say. So I think that some of what's emerging in terms of earth law or the rights of nature, or the rights of Mother Earth, those sorts of approaches, both within the formal Western jurisprudence kind of stuff, but not just in the West, but including in the South. Where that especially is being combined with community or indigenous struggles. So where you have actually a combination of, of sort of middle class, privileged kind of peoples who are part of ecological movements, but combining also with indigenous struggles or local community struggles, and using things like the rights of nature or the rights of Mother Earth or earth law kind of stuff. You actually are beginning to see transformations on the ground in terms of at least being able to protect certain ecosystems, river systems, mountains, forests in many different parts of the earth, of the world. So in that sense, it's not just theory. I think there is a practical application. What I think is really interesting is not just how it's being successful in some parts of the world, but also how, because there is a collaboration between different sections of society where you're getting people from the privileged sections, but also the indigenous peoples, communities, the disprivileged section, marginalized sections coming together. There is, in fact, also the attempt to move beyond the law, which is what I was saying earlier, that the rights of nature discourse should not remain within the formal legalistic constraints. It needs to go beyond that in terms of looking at how do people change their livelihoods, their lifestyles and their ways of living and thinking, also to respect nature fundamentally, so that it's not just because it's in the law, but it is because it is how we should be living. So in that sense, the sort of ontological, epistemological thing that Sam was also talking about is beginning to happen in some parts of the world. So I think we are seeing these practical implications of it. Just a quick, and this is where I think there's a very interesting additional comment I could make on what Sam said. The degrowth, for all its advances, still has a bit of a weakness in terms of an adequate theory of the state, which I agree with. I think this is where a number of the movements and notions from the global south could be very, very useful for the degrowth movement. So for instance, here in India, when we speak about Swaraj or what we call radical ecological democracy, we're already building into it a certain notion of the state, which could be either, so one ideal vision would be a stateless society, some form of anarchy in its best sense. In fact, Gandhi often argued that he even called himself an anarchist. Or where we have negotiated relative autonomy by communities where they're negotiating their power vis-a-vis the state and saying democracy. Just to give you one slogan in central India villages, that we elect the government in New Delhi and we'll make it accountable. In our village, we are the government, and we won't accept anybody's diktat from above. So that's the kind of range of practices, but also from this theories or worldviews or visions of what the state, or either statelessness, like in the Zapatista and the Kurdish movement, or negotiated democracy vis-a-vis the state can look like. And I think there's a lot of diverse things happening along these. And finally, also in terms of the argument for bioregionalism, to say that instead of the nation states, which is what we have right now, we start moving towards looking at political boundaries from a cultural and ecological perspective. River basins as a political unit, mountain ranges as a political unit, contiguous forest ecosystems as a political unit, which currently are cut across by nation state boundaries with all sorts of problematic impacts. So how do we reimagine politics also, political boundaries also, from ecological, cultural, language perspectives, is also very much part of this emerging practice and new theories of democracy, let's say, not just the state, but of democracy. And I think the degrowth movement in Europe could probably pick up a lot from these. Yeah, for the moment, that's it. Thanks.
Thanks. Yeah, Sam or Margot?
I'm happy to go.
Yeah.
Okay, I'll try to be brief in response to the two questions. First of all, the how. I think I'm going to, I've got several favorite quotes. Two of them are from Einstein. One is that no problem can be solved at the same level of consciousness that created it. So the precondition is to reimagine, is to move away from the level of consciousness that's brought us into the polycrisis. Whatever we do is not going to be without contradictions. I think giving the emergent movement for rights of nature that in Latin America, in New Zealand, of all places, the United States, is a way of reimagining, of prefiguring, of thinking differently. As I said earlier on, I don't think rights are unproblematic or without contradiction. And certainly Buen Vivir has not actually put an end to Buen Vivir and ideas of plurinationality, different forms of state in relation to what Ashish was saying, has certainly not stopped extractive development in Ecuador, Colombia, Bolivia, and elsewhere. But I think it does, the rights of nature movement, which is now being debated, say, in the European Parliament and elsewhere, does indicate how indigenous legal traditions and cosmovisions can be more broadly disseminated, can prefigure potential change. This, in relation to the effectiveness and usefulness of indigenous onto-epistemologies, I think it's important to learn from without romanticizing indigenous knowledge and ideas. So I think there is, I've written in the past about epistemologies of mastery and domination. And again, this is very much Western Eurocentric kind of thinking, colonialism, etc., patriarchy, and epistemologies of mastery include domination of nature. And I think what we need epistemologies of humility. We need to be willing to learn from and to take the wisdom from other cultures, to think in pluriversal ways, in other words, rather than universal one world ways. We need to, another quote from Einstein is he said that insanity is doing the same thing over and over again and expecting a different result. And that's kind of law as usual, business as usual, and development as usual. We have to try and stop being insane. And a final quote is from Frederick Jameson, who said, and this is the scale of the problem, that it is easier to imagine the end of the world than it is to imagine the end of capitalism. And I think he's right. The problem is that capitalism is on the way to bringing about the end of the world.
Thanks, Sam. Margot, do you want to come in? I know you spoke a little bit also about reimagining rights, or kind of, yeah, the work that's been done recently on reinterpreting rights. So maybe you could come in on that as well.
Sure, thank you. Thanks, Birsha. So this was really terrific. So I have a couple comments, maybe starting a little bit with the sort of combined issue of the place of the state. and a theory of state, which I think links in a way to Jude's question about how to move forward. And it's linked to that because international human rights law fundamentally empowers the state, right? So if we want to think about the role of the state, part of the change, if we're thinking about emancipating human rights and the use of human rights, is to think about how we engage with and situate the state within international human rights law. So a couple of points here. So one would be, and this emerged out of a conversation I had with a few people about a year or two ago at a workshop on the commons in human rights. And that's this idea about thinking, and in my own thinking, it emerged out of other work that I've read on commoning and law, in particular some work by Ugo Matai on the ecology of law and a few others. But the point really here that emerged out of this conversation in international human rights law was to think about not just sort of respect, protect, fulfill, which is how human rights lawyers traditionally think about the obligations, the tripartite obligations of state, but actually the role of the state in, I use the language of facilitating. A colleague at the meeting used the language of enabling these alternative modes. So making the state its legitimacy contingent on and interpreting obligations through not just giving effect to human rights and protecting human rights, but actually facilitating in some really deeply substantive ways these alternative sovereignties, alternative forms of decision making, right? Alternative forms of lawmaking. So really, it disempower the state in terms of the kinds of power and oversight it currently holds, and increasingly think of the state as a facilitator of or enabler, and loosening its hold that it's traditionally had. So tying that in, the reimagining of the state, tying it into international human rights law, which is not easy to do precisely because the state is so central to everything. I think another point on on thinking past what we have now and this idea of emancipating human rights is to expose consistently the structural problems at the root of human rights violations. And this is also through processes of litigation. I've written a bit on this recently. I drew on some cases that the Committee on Economic, Social, Cultural Rights had dealt with recently with regards to austerity in Spain, and the eviction of some various families because they couldn't pay the rent under conditions of austerity. And on the one hand, that's a right to housing issue and so forth. But I'm not going to sort of elaborate here at the moment, but I unpack that to effectively show, and the committee does some important, even though it's fairly nascent, work on thinking through what gave rise to these problems in the first place, right? Or what are the structural issues? And to think also about not only the right to property of the bank who owned the flat in one particular case vis-a-vis the family who was being evicted, but whether the bank actually needed that money, because it was a bank rather than, let's say, the committee draws this distinction in subsequent case law, whether it be a private person who owned that flat and relied on the income for their living. So it starts to unpack deeper elements, and in my work on that, I sort of start exposing what the speculation that was taking place in Spain and the root causes of the lack of social housing to begin with, and so forth. Others have written on this as well. Rob Knox really nicely in his work on strategy and tactics. So the idea here is really to expose the structural and to see our engagement with international human rights law as one step towards something far bigger, and to work in a way that actually doesn't allow for co-optation and re-empowering of the state and so forth. And relatedly, but I think this is sort of have been made tacit, and I flagged it in my intervention, is the first step for us as human rights lawyers, for those of us who are consider ourselves human rights or engage with trying to emancipate international human rights law, is really to seek to ensure that it's not part of the problem. So what I've been talking about now is really how we could rethink it and redeploy it, and how we could be strategic intellectually and use the law in that way. But the initial problem is really that in very significant ways, international human rights law is part of the problem. And that's what I sought to expose with looking at the way in which socioeconomic rights has long relied on growth and celebrated redistribution and advanced it in the Sustainable Development Goals, which is a deeply problematic set of sustainable development goals, or deeply problematic in terms of its ambition and its underlying philosophy and thinking. So we don't want to be part of the problem, right? And we're still even part of the problem, even though what I tried to highlight is that there's some change in direction and some areas opening up, and we can think about that more fully. And then finally, my last, and I'll be briefer on the participant's first question, about the role for Indigenous rights or Indigenous peoples. And I guess I want to make 2 points. One is, there's something very important and riven with risk when we translate Indigenous epistemologies, Indigenous hopes and dreams and rights, right, into law and into the language of rights. And it's the same for peasants. So there's a trade-off in that engagement, right? You get something, but you give something away. And the things we give away are long and deep in that process. It's not to say that it's not worth it, and that's probably a different seminar on that topic, but it is to say that there's that translation process brings with it many problems. And I've written looking at that with regards to the Peasant Declaration, which I mentioned it here today in my intervention, which in many ways is radical, extreme. There's no question in my mind that it's a declaration, that addresses the rise of rights against capitalism and against global capital. But at the same time, there's strands within that declaration that are deeply problematic. I mentioned the benefit sharing, but that's not the only one. So it is invariably a product of negotiation and overall something that we could recognize as significant and a significant gain. But these are, what we have to do is be alive to what happens when we start to do law and when we rely on human rights, and be savvy and cognizant of that system of translation, and engage with it strategically at every level. Thanks.
You're muted, Birsha.
Sorry, we have about 5 minutes left, so I'll just take one more question from the chat. Perhaps this question from Sarwar about ecological debt, and it seems that kind of redress or compensation has quite an important part of any sort of degrowth narrative, both within countries as well as both between countries and with and maybe even within countries, right? So I wanted, and that's perhaps where law can play quite an important part. And Sam, maybe I'll put this one to you first, especially since you brought up COP28, climate litigation, things like that. Do you see any role in those processes or through litigation to address these kind of points? And then we can go to Ashish and Margot for the last word.
Yeah, well, clearly, I mean, there are massive ecological debts owed by the global north to the global south. Since the Framework Convention on Climate Change was adopted in 1992, the Alliance of Small Island States has been putting loss and damage on the agenda. So we're talking since 1992, more than 3 decades. Finally, in Sharm el-Sheikh at last year's COP, the COP nearly failed because of the unwillingness of developed countries to put loss and damage on the agenda. A mechanism was set up, although there's an existing Warsaw mechanism on loss and damage. The Group of 77 plus China, the Global South finally prevailed, first of all, on getting loss and damage, which is basically about compensation for ecological debts, about reparative justice, onto the agenda. They've agreed to set up a new mechanism and to seek funds, and part of the discussions in Paris today and tomorrow will be on loss and damage. But that is one way where the law is potentially fruitful. But I caution here, the history of the Framework Convention and the Paris Agreement suggests that there will be continued attempts to depoliticize, to push loss and damage away from compensation and reparative justice into technological issues like risk assessment, insurance, etc. But here, this is an absolutely fundamental dividing line over the issue of ecological debts in the UNFCCC at the moment.
Thanks, Sam. Maybe Margot, you want any last thoughts, and then Ashish.
I'm happy to leave it there. It's great to hear from Sam on something that he's worked on so much. So I don't really have anything to add on that, except I guess just to merely say that it's part of a much bigger set of reflections and significant sort of center point around the idea of what we owe, what's owed to other people, and there's been so little movement in that direction so far that it's hard to be optimistic through a model that thinks about what's owed, because what has been taken is in many ways irreparable, right? So this is a small attempt to repair the irreparable effectively. But insofar as people like Sam think that there's strategic possibility, then I would celebrate that. But I see us as the debt being so enormous and so long neglected, and so beyond what any kind of compensatory mechanism can offer, that the problems and the fixes and the change has to be much deeper and wider. But I'm glad Sam holds some optimism there, if I can put it that way.
I don't know if he's that optimistic. Ashish, last words maybe on ecological debt, or anything else as we.
No, I agree with a little bit of glimmer of hope that Sam has put, but also with the very strong caution that I think Margot is. But I mean, for me, actually, what is really important, though it's long term and difficult, is building up people's power. As long as we kind of try and depend on governments to provide, to think about things like ecological debt, or to provide enough monies for the global south to be able to transition in a just way, etc., I just don't think that it's going to happen unless people's power is built up both in the global north and the global south. I recently did a paper for one of the official aid agencies of Europe on what the aid agencies, what global cooperation could look like. And one of the things was, one of the points was to look internally and see how do you decolonize your own countries, the global north, because the global north is as colonized as the global south is, and the global south in much worse, much more brutal ways, of course. But in terms of mindsets, the global north is as colonized, or in terms of things like, of course, what a colleague has called the imperial mode of living. And so I think there's a lot of work that northern groups, aid agencies, northern groups, NGOs, civil society, people's movements, and to the extent governments might be listening, have to do, not to sort of help the South, but to actually even help themselves to decolonize. So I need just adding that as a perspective.
Thank you very much. Thank you. Thanks, Ashish. Really, thank you, all three of you, Sam, Margot, and Ashish, for such rich interventions and contributions, which, a lot for us to take away, really. So just for the rest of the audience, we are hoping to do some more sort of events on this theme once the sort of academic year begins. And so it's a kind of longer engagement with this topic. So please stay tuned. But otherwise, thank you again to all the panelists and for the audience for your time today. Have a lovely evening wherever you are. Thank you.
Thank you.
Thanks a lot. Thank you. Thanks. Bye. Bye. Sam, Margot. Bye. Birsha.
Bye.
Bye, Ashish.
Bye, and thanks.